Inventor Led Business-Grade Invention Disclosures. Hello and welcome back to Invent Anything. Coming up, we're going to connect this invention disclosure idea in terms of process and types, etc., with the outputs, which are provisionals or patent applications. Talk about the problems that we find with the whole process, and then talk about why should it be inventor-led, why should it be business-grade. At the end of the day, we're going to show you how claims, enablement, and all that stuff can give you a great ROI for the same process. So take a listen.
Inventions keep the world spinning. From fire in the wheel to today's high tech, inventions power change. Turn your inventions into reality. Learn how to get your ideas to market. This is Invent Anything with John Cronin.
And today we'll cover 6 different topics. The first is the invention disclosure process itself, the types of invention disclosures, points of views, use cases. And then we'll move on to topic number 2, which is how that all leads to a provisional or patent application, and talk about some of the problems we found with this whole process. I want to move to topic number 3 to talk about what patent counsel does, because you might, if you don't know, we can at least tell you, but if you have been involved, this will allow you to recollect why they're needed in the process. But then move to the problem and what is done today with patent counsel, to why we need to add this sort of inventive-led kind of thinking to the invention disclosure. But we'll do it with some examples. And then change the thinking to adding business-grade thinking to the invention disclosures, and we'll give you some examples of that. And then finally, we'll talk about the value of putting it all together as an inventor-led business-grade invention disclosure. This is John Cronin from Invent Anything, and I hope you enjoyed this podcast. As usual, we will talk about the audience that generally I think about when I'm doing these podcasts. And for this particular podcast on inventor-led business-grade invention disclosures, I think it's really very useful for those who have already been through the patent process, because this could be an eye-opener of what could be done different. Another part of the audience could be those who are considering their first patent filing. Certainly, this particular podcast will give you a big 360 view of what you need to do. A third sort of audience is those CEOs who want to get a lot of value out of spending money on their patents and applications. This is definitely for you. But for all those that might be looking at the whole patent experience, maybe you've been through this, and you want to have it to have more value, this is definitely for you. Another area of audience might be for those who went through the process of patenting and just think that there should be more. And finally, another audience that I think would kind of really hold this as valuable, this podcast, would be kind of like a 360 view around this whole patent filing process. Because, it starts with the inventor, but it ends with the business value. So why not have it more inventor-led and business grade? So coming up, we're going to start with the invention disclosure process itself and show how these disclosures kind of do everything from logging the human capital into management, how you can pull investors and lawyers and business guys together. But then we're going to show how all of this leads to a provisional or patent application. And we're going to reveal some of the issues there, the gaps, the prior art issues, the obviousness, and all the things that are missing that maybe an inventor-led or business-grade thinking would do. So let's get into topic number 1, the invention disclosure. I'm going to talk about things about the process, the types of invention disclosures, points of views, and use cases. So first of all, in my background, I started at IBM. I was there for about 18 years. I became the top inventor of the company after about 4 or 5 years with over 100 patents. And I had to write a lot of invention disclosures. So I became kind of expert at how to write these things up. But then over the last 30 years, with over 2,000 clients and filing thousands and thousands of invention disclosures, I really honed the knitting with my team about how to do this really well. I myself have 2,500 patents, and I've written all of these myself, so I have a lot of experience here. So in that process of having that experience, I've also had the opportunity of training tens of thousands of people on this very topic. So at least you're in good hands here. So one of the things about sort of the invention disclosure definition, the definition here is a document constructed as the first step of the patent process. From a process point of view, many times, believe it or not, this step is even skipped. In other words, the inventor gets with a patent attorney and just gets on the phone. So they don't even go through the process of writing an invention disclosure. They go right to the patent. Uh, if I take a look at the types of invention disclosures that we see in the industry, it's everything from that napkin you've learned about, where people are sharing ideas and they literally give the napkin to the patent attorney, or all the way up to a master's thesis. Somebody works on something for years and they have this huge document, and they'll turn that in as the invention disclosure. The other thing about this whole process here is the point of view is really important. Like for management, the point of view of an invention disclosure is really this is the first time that they're documenting or logging in human capital. From the point of view of the docketing groups in internally, for legal counsel or externally, it's the first document that they can log into the document system. From the point of view of the inventor, it's really a chore. It takes too much time. We've done countless studies that show inventors love inventing, but they hate documenting. They may actually have an inventor notebook that might replace the disclosure form, but in general, inventors consider this a chore. And so in many organizations, they don't get invention disclosures, they don't get inventions because the process of invention disclosure just takes too much time and it's too arduous. And more than that, most people aren't trained how to do it well. If you take a patent counsel, there's differences between an internal and external counsel. Internal patent counsel actually needs the invention disclosure as their key to start the process off. Outside counsel does the same thing, but they're actually charging billable hours. So if you don't give them an invention disclosure, chances are their billable hours to create the invention disclosure to start with is going to go up. Or if you give them a light invention disclosure, their billable hours is going to go up. If you give them a thesis, their billable hours is going to go way up. And so how to reduce billable hours and get the right billable hours means writing a really good invention disclosure. From the point of view of the board or investors, basically this is the beginning of owning an asset, and have been on many boards myself, both chairman and board members, always kind of calling for getting the intellectual assets documented. And finally, from the point of view of quality, one of the things that an invention disclosure does is it really helps with enablement. It's one of the benefits. We do have podcasts on this enablement if you want to take a look at that in our series, Invent Anything. But the invention disclosure process is the beginning of good enablement, which adds to the quality of the invention. For topic number 2, we want to talk about the invention disclosure to provisional or patent process. And while we do that, talk about the problems we found. First of all, the format is either too simple or too open-ended or too detailed. There is no one format for an invention disclosure, but a lot of companies work hard to develop that. But if you're not a large company, then you just got a group of engineers or technical people, software programmers or whatever, and you've never seen an invention disclosure form, it's very likely that you'll probably just get on the web and try to find one. But they're very loose and open-ended. Maybe have the problem, maybe have described the invention, who the inventors are, what's the market size, things like that. So from a format perspective, there is no right format, but one could actually get a best-in-class format if you really wanted to and spend time doing that. The invention disclosure needs to start the invention, which then should lead to the patent, which then leads to claims. Most of the writers of these invention disclosures don't have any understanding of claims, nor do they have understandings of what the patent counsel is going to do with it. So because of that, they're writing up a document where they really don't have an idea of what the result's going to be. And that's a problem right there. Most inventors, when they write up an invention disclosure, don't know what enablement is. Again, we have a podcast on that you could take a look at. But it's a huge problem if you don't know the type of enablement you're looking for. Meaning, how do you write the invention disclosure so that you can convince another technical person that your invention works? Another thing that's not done is almost all disclosures, very few people know how to search the prior art to talk about how their invention may be different than the prior art. So invention disclosures we find in general don't do that. And that's another issue for a patent counsel. They have to then go search the art. It's so much better to have the inventor talk about the art and why they think it's different than starting fresh with not understanding any of it and having to do a formal prior art search. Another thing that stops the inventor in the invention disclosure process and really creates a lot of errors is the word called obviousness. A lot of inventors, as they start with the invention disclosure form, literally stop and don't fill the rest of it out because they start thinking that what they're doing is obvious. A technical person using the word obvious is really a class 1 error, I think, in the patent process because obviousness is a legal question, not a technical question. There's certainly layman's views of what obviousness means, But I have found if you apply the word obviousness to your invention and you're not a lawyer, you're really making a big mistake. Another thing about the invention disclosure process is most inventors don't understand that you could have an invention, which could be a method, or it could be a composition of matter, or an article of manufacture, or a system, or it could be a functional invention or a business model. You could take any kind of invention, and as you start to describe it, understanding the IP type that you want to create. Is it a method, a set of steps, or is it a system, a set of apparatus? That's a decision that needs to be made by generally people who've done this before. So when inventors get started, they tend not to even think this way. They're just writing up sort of what's in their head without any structure. Another thing is there's generally no understanding of sort of these connections between uh, the, the invention disclosure and where it's going to look, what it's going to look like based upon when it's filed. In almost all cases, I've found that when someone writes up an invention disclosure, it ends up to the patent counsel, which ends up going to maybe the management of the company to see if they want to spend the money doing it. But at some point, the patent attorney writes up the patent and then writes up the claim. And then it goes into the patent office, and you get office actions. And then finally, your patent issues, or it's granted. You have your final claims. There's very little connection between the invention disclosure that was written and the final claims that you got because it took years. So it's kind of interesting. Invention disclosure, the problem is you're writing up something by which the result and all the work that's going to be done is going to happen 3 years from now. So how do you really solve that? And that's where the sort of inventor-led thinking came from, because inventors can kind of think forward about that and build in the invention disclosure the kind of specifications that allow you to get the claims that you want. Another thing is likely without a mentor or an inventor basically there's a lot of problems that come up. So for instance, if you're writing up an invention, maybe the invention is easy to get around. Maybe you're not thinking about how to expand it with the value chain. Maybe you're not thinking about species and genus and how by describing one thing, you could get very limited. But if you describe the one thing in multiple examples, you get a larger genus to get more. There's all these tricks of the inventive mind that somebody writing up the invention disclosure would probably never think of unless they were a seasoned inventor. Also, another key problem is that there's generally no business input. Sometimes your manager would say, or the boss, or the CEO, or the founder, or the investor would say, we need to write this stuff up. But they don't tell you what to write up. So you go off and do it yourself. So without understanding what the investment is for and thinking about how your invention can impact the customer, or how it can help against a competitor, or how it can help for your brand, or even how it would be for leverage or valuation, without understanding that, how do you write a good business grade invention disclosure? So we kind of recognize that that thinking needs to be there. So we need the patent counsel, of course, but we need to have this inventor and this sort of business thinking at the same time. So that's where we're headed. So coming up, we're going to talk about patent counsel and the invention disclosure process and the value they bring, the legal value, the understanding of sort of the documentations, the claims, etc. But then we're going to then talk about the beginning of how to add more value by having an inventor-led invention disclosure. We're going to show how the inventor thinking could take any invention and expand it by inventing around it on top. Figure abstraction, enablement thinking, species genus, trade secret, master disclosures, all the kind of things that an inventor might think about. We'll talk about that, and we'll give one example per, so kind of even a layperson would understand it. So stay tuned. So let's jump into topic number 3, patent counsel and the invention disclosure, and talk about the value add that patent counsel brings. So first of all, I'm not a patent attorney or agent. I don't practice law, and I certainly can write up my own patents. The practice of law means that the inventor can write up his own patent and patent claims. But in generally working for third parties, we don't do that, but we do write up lots of inventions. But the patent counsel is the ones that file them. So that's a key reason right there that it's best to have an expert file with the patent office. Certainly, patent counsel provides all sorts of legal advice, but their area of expertise is practicing law. Certainly, they can talk about strategy, they can talk about all sorts of things, but basically, you're hiring them to do the legal work. So they can practice in front of the patent office for you, and they can write licensing agreements and contracts, but generally, everything else is really more strategic business advice, which they're certainly very good at, but you're hiring them to practice law. From the invention disclosure standpoint, they're the ones that keep track of all the legal requirements, all the dates, all the fees. It's a lot of work. So when you're hiring a patent attorney group, you're getting a huge back office behind them generally of keeping track of things. There's a lot of things to keep track of. So there's a huge value add there. Another thing is that there's a huge value add because they're practicing what would be in the MPEP, the Manual for Patent Examination Procedures. There's a huge set of books, volumes of information about all the things that you need to do. What form needs to be filed? What format does it have to be in? What are the date ranges? What are the fees? All that stuff. All that format and structure, patent counsels, that's what they do. From an invention disclosure perspective, their job generally is to listen to what you've got, try to assess what's novel, and then maybe do some sort of level of a prior art. Some attorneys, don't think that you should do a prior art study. You should just try to go for the claims and see what the examiner says about the prior art. So whether they do a prior art or not, certainly one of the helpful things they do is try to assess the novelty. And that's what you'll get into the sort of definition of what is obvious and not. Another thing the Patent Counsel does is to really ensure that the invention is enabled. That word means a lot to Patent Counsel and people like myself that do this for a living. But to an inventor, that might not necessarily ring as to being something that it's important. Although no engineer or software person or chemical person would ever think of, having a prototype without actually making it, enabling it. The enablement also has to be done structurally right inside of a patent application. Another thing that patent counsels do is they help determine, what continuations may be filed. So when they build a specification of the patent, they're always worried about when you get the patent issued, can we file a continuation? That's really a legal consideration, is to figure out what new claims can be constructed that can be continued. And from the inventor disclosure perspective, the patent counsel, basically, they're the ones that, create the claims. And that's an art form. I mean, the difference between two attorneys and the ability of writing claims is drastically different. That is their art form. And I can tell you that I've met attorneys that can take a concept and turn it into claims that are just unbelievably valuable. The same idea in a different patent counsel, they might not be able to get those valuable claims. So claims is the art form. It's the going over to the house to have dinner for one of your friends who happens to be a French chef. You're probably going to get a great dinner that night. And they're the ones who decide on claim types and claim breadth and all the rest. Another thing is that what they also try to do, and there's a requirement for them to make sure that inventorship is correct. That is, from the claims of the invention to what's in the spec, is there an inventor making a contribution to at least one part of one claim of the invention? So part of what they're trying to do is to ensure inventorship is correct, because if it isn't correct at the end of the day, the patent could become issued but become invalidated because of incorrect inventorship. So it's a legal requirement. Another thing is the patent counsel spend the time handling what's called the office actions with the patent office. Because when you file the patent with its fees, etc., you then wait, the examiner gets back to you saying why they objected. Most patents are objected at least one time. And so they're the ones that would sort of work with you and the examiner to write documents back and forth trying to prove why the invention should be issued. So they handle office actions. And finally, they'll do some more legal work if needed. They might take the invention disclosure or the patent that's filed, and they might assess evidence of use or freedom to operate. Certainly, there's a technical side of that. My firm does evidence of use and freedom to operate all the time from the technical standpoint. But getting a legal reading and a legal document from an attorney, what their legal assessment is of the freedom to operate evidence of use, is a very powerful way of connecting that invention disclosure and patent to the real world. So yes, we need them. There's a huge amount of value by patent counsel. So in no way, listening to this podcast, should you even think about doing something without an attorney. But let's get into sort of the more specific rationale as to why this needs to be inventor-led. Now, once again, I'm an inventor with about 2,500 patents myself, and I've done a lot of inventor-led inventions. Part of the business model by which I work is we help invent for others. So inventor-led is something that I do every day, and so this is sort of fun to talk about it. So let's just say that you're an inventor and you have a disclosure, and you're thinking about, how to improve it. So you talk to the attorney, you kind of figure out what's novel, what's a claim, but you sort of stop right there and say, well, what is John talking about, inventor-led? So one of the things is how to sort of think about thinking, right? A while ago, I got really influenced by creative thinking tools. I started reading books on how you think, practicing those creative thinking procedures to try to be even more creative. There's all sorts of books that are written on thinking. There really isn't a book written on inventor thinking. There's some kind of cool books out there about creative thinking or inventive thinking a bit, like Edward de Bono's Six Thinking Hats. But there's really, beyond the patent counsel's point of view, which I just talked about, there's very little sort of what you can go to get educated on how to get a really good inventor-led kind of construct. So basically, we have a thinking process that has about 20 different areas that we use as a checklist to try to expand the invention. I don't have time for them all here, but I want to give you some with some examples. But this is kind of the way an inventor would think. If you already got your disclosure, you already kind of know what you're doing, you know what's novel. The patent attorney has a good example of where they want to head. Now it's time for thinking, inventor-led thinking. So the first thing you might want to think about is inventing around your own invention. Why would you want to do that? Because if you invent around your own invention, you now expand your invention to include your invention in the invent around. So if somebody else comes up with the invent around, you would still own it. So for instance, suppose you had a smart thermostat and what you decided to do, is have a design for sensing occupancy and motion. And so what you can do now is you can take that information in your smart thermostat and use information about the people in the room and the things in the room to determine how to adjust the thermostat. So it's not just a smart thermostat by setting it plus or minus and sort of forecasting ahead or backwards. It's actually influenced by things that it can read. It can take a sense of how many people in the room and maybe adjust the calculation. So your smart sensor could be invented around by maybe having it be smarter in a different way. So why not capture that? Another way, another tool, if you will, is invent on top of. Here, what you're trying to do is think about how the invention, can be done, but also every single invention that is defined creates another problem to solve. So the idea here is to sort of think about that and add the new ideas with the problems that the invention disclosure is going to create. So suppose you have a smart oven and it detects sort of a left-on behavior. Well, that's really good to have an alarm, right? But sort of if you think about that, when would you want that? What would be the next step? Well, that alarm might want to go to an app because maybe the system needs to go to a caregiver because, and if all of a sudden your mom is leaving the stove on a lot, and you would know that, a caregiver would start to think that person would need help. So that's inventing on top of taking an idea and thinking about some of the opportunities of the next steps. Another sort of tool is what I'll call figure abstraction. Here, we're kind of doing is taking the invention and creating figures, right? So figure abstraction is a technique where you kind of take the figure and think about how to expand that figure into different directions. Tony Buzan called the idea mind mapping, which one thing makes you think of another, and that other thing makes you think of another. So it could just be this thing related to another thing, which related to another thing, and through the mind map, you can connect them physically and see it. Well, why not do that with your own figures? So you might have a drone navigation system, right? And you draw your figure diagrams for that. But then you say, wait a minute, I could abstract this up to also have a flight control system or maybe a fleet coordination platform. So I'm taking my drone navigation invention and expanding it in a way around abstracting it up or extracting it differently. So now the invention is going to cover fleet coordination and flight control systems, not just a navigation system on a sensor of a drone. Another way of sort of thinking about it is a tool we call enablement thinking. That is to sort of get a focus on where the invention's enabled, and then from that, make sure it's enabled, but then do a better job of really enabling it with more examples. So here, suppose you have a wearable heart monitor and it has specific sensor types. Well, that's great, but maybe when you think through it, maybe there's the best sampling rate. You sample it maybe, a certain rate to get even the fastest heartbeat. And maybe what you do with the data is you actually are challenging the data in the device to make sure it's always within a normal range, but not jumping past a range that the human heart couldn't actually do. So you could take that wearable heart monitor sensor and enable it, but then make it really enabled to deal with all the variation. So that's pretty cool. Another thing is instead of inventing on top, one of the inventive thinking tools is inventing underneath. So, and this is something that's overlooked quite a bit, we find. So what you want to do is take a look at where the invention is and do a really good job in getting more details underneath it. So suppose we had like a voice assisted patent that protects sort of a wake word that basically, you say, hello, somebody, and the computer wakes up. Well, that's great. I mean, the algorithm gets predefined what the word is and it listens. But maybe you can invent underneath by saying, supposing there's a lot of people talking and that word comes up. Well, that word may come up out of context. Or if it comes out of context, maybe you don't use it to wake the system up. How many times did the damn thing come on? When you're watching TV, my TV turns on my Alexa. And so having context around sort of a very specific, algorithm. So this is a way of inventing underneath, taking like a voice assisted patent, wake up word, and then turning it into something much more detailed. This is the inventive mind that's going through this checklist of all the things you could do. Think about specious genus thinking. Basically, this is the idea of saying if you can give more than one example, two examples, you can get more broad. So suppose you have a charging system that claims sort of wireless power transfer. Well, maybe you start thinking about, well, there could be at least two ways, three ways to do it. One could be inductive, another could be resonant, another could be RF. These are three different ways to do it. So now you have a wireless charging system of three different types. So it could be a multi-hybrid component charging system using combinations of them. So the inventor sort of comes in, looks at your specific thing, comes up with other examples, and does this genus thinking. Another thing an inventor can do inventor-led expansion is sort of thinking about trade secrets. That's a type of thinking. So knowing how to parse out trade secrets in an invention so you can patent part and trade secret parts gives you double protection. So supposing you have a battery patent that discloses a cell structure. Well, you might be able to do that, but maybe you don't need to add the electrolyte formulation. Keep that as a trade secret. So the structure can be done generically for any kind of electrolyte, and you hold your proprietary electrolyte to yourself. That's sort of trade secret thinking. The inventor recognizes that you don't have to disclose everything. You only want to disclose the things that you're going to claim. Another thing is sort of master disclosure thinking. This is an advanced concept for those inventors that find that they might have, like I just talked to an inventor right before this call, they have over 100 patents, and they certainly get this idea of sort of a master disclosure thinking, meaning you take your specification, and the prior art and think about continuations, and the inventor kind of expands the invention in all sorts of different ways. So suppose you have the autonomous emergency stopping vehicle, right, that knows how to stop, and basically you're doing a camera placement. Well, now you could take that and kind of expand it deeply into the software, or deeply into the controller, or deeply into an AI machine learning for road conditions or road clutter. So you could take that basic invention and think about how to expand it along all the things that your invention will touch. Now your specification grows from 20, 30 pages to maybe 40 or 50 pages, but the patent would have many, many patents that could be derived from it through continuations. I could go on and on about all sorts of, quote, inventor thinking kind of tools. Use them all the time. But one I kind of is kind of fun to give you a totally different type of thinking is called impossible problem expansion. And that is to sort of think about the problem that the invention creates and think about kind of an impossible problem that you could sort of riff off of. So suppose you have a medical sensor, right, that describes the blood chemistry. Well, if you can detect the blood chemistry, wouldn't that say that you're trying to do that for a reason? Like too much sugar in your blood or too much cortisol in your blood, etc. So if the monitor can understand blood chemistry, the impossible thing would be, could the monitor then dispense, the agent into the bloodstream that actually would reduce the thing that it's trying to measure? So now I've got sort of a medical sensor that has associated with it a delivery system that will deliver to sort of knock down the thing that's trying to measure as it's getting out of spec. Sort of impossible problem thinking. I mentioned about 9 different inventive thinking tools. Uh, we have checklists of some of this stuff that when we do it. But just imagine that you have your invention disclosure done. The patent attorney tells you, hey, we're ready to go. We know it's novel. And you say, wait a minute. Before we do that, let's do an inventor-led session where we can take that one invention disclosure and see if we can expand it. The 9 things that I talked about, maybe 3 of them will give you some real ahas that you want to add. But the thing is, just like a checklist that a flight, pilot would have, you want him to go through the checklist to make sure the plane's the best it can be. Why not have an inventor-led checklist in your invention disclosure process? So coming up, we're going to move on to business-grade invention disclosures and introduce business thinking, the same one we just talked about, invention disclosure and inventor-led thinking. And then we're going to sort of put them together. We're going to take inventor-led and business-grade, put them together, and then show the value and the returns we won't get when one does those together. So stay tuned. So topic number 5, business grade invention disclosures. So the patent counsel and you have worked out an invention disclosure. You kind of know what novel, you kind of know what you're going after, uh, and you say, let's stop. Let's add this inventor-led, discussion to this because we want to expand this thing the way I just talked about. But now you say, well, wait a minute. We also want to do the same thing for business thinking, or what we call business grade invention disclosures. What does that mean? Well, first of all, uh, patent counsels could understand a little bit about your business. They certainly don't understand your business the way, say, the CEO does, the way others does. Inventor like myself, I certainly understand invention, but maybe I don't understand the business. Over time, I've been working with several thousands of companies, so I've seen patterns in business. So I feel very comfortable to lead this sort of business grade invention expansion. But I will say that business thinking is really important when you're writing up an invention disclosure. So let's get into it. So first of all, the last time I talked about inventor thinking, and I was saying, there's no real book that teaches you how to do inventor thinking. Maybe telling you the stories of inventors. I mentioned De Bono and his 6 thinking hats and things like that. What kind of books on business would you even consider that you might want to read or apply to this business grade invention disclosure? Well, I mean, a while back, I was really influenced by a book called The Profit Zone by Morrison that had 22 business models for profit in the book. And this was in the dot-com area where all of a sudden we started seeing software being applied to business models. After about 22 of these business models, I recognized there were hundreds of business models. So from a business perspective, let's bring on sort of the business thinking hat, and I'll give you another set of 8 or 9 things that you could add, and there's more, and I'll give you some samples or examples of that. So first of all, any company has a business strategy, right? So you'd really like your invention disclosure to connect to your business strategy. I mean, there are many invention disclosures written that the inventor thinks are really important, and sort of management never gets involved. They just write the check and let it go. So let's just talk about how. How can the invention enhance and overlap with specifically the business, the product, the technology, the platform, or maybe help with PR or something? How can they connect with the business strategy? So supposing you have an invention like a connected forklift and you want to enhance it, and maybe you kind of recognize that the business is building these forklifts, but they're also trying to make it more safe and they're kind of educating the forklift drivers. So maybe to your invention of the forklifts, you can add some sort of operator fatigue detection system. And now the company can bundle the forklift, the connected forklift, to Wi-Fi and the cloud, to also some algorithm for operator fatigue. Now what you're doing is you're building more revenue for the same company. So this is a way that you could take the company's business strategy, take the invention disclosure, and add to it to make it more valuable. Now, one way to make something more valuable from a business perspective is to take the invention and expand it out to the value chain. Supposing you have a solar inverter invention and you expand it to say that you can now add to the inverter in the solar cell some sort of grid level forecasting software. So now that each solar panel can have a little bit of forecasting based upon the sun and the grid that it knows is charging. That's a way to expand it in the value chain. Solar cells with inverters are sold to solar cell companies, but the value chain is the customer's customer is using it to manage the grid. So just thinking about the value chain and drawing it out and asking the question, how does my invention disclosure impact the value chain? And then adding that. Another great tool comes from some of the work that I've watched over the years with creative thinking tools, and that is called the how-why letter of abstraction. Have you noticed that when you're talking to kids, they're always asking how things work, how does that work, how does that work? And as they get a little bit older, they stop asking the how questions and start asking the why questions. Why is this happening? Why is that happening? So by asking why, or how, you're moving the conversation. Why is moving it towards broader things. How is moving it toward narrower things. Well, obviously, asking why is going to make it broader. Therefore, from the perspective of business, how can my invention broadly help the value of my business? So suppose you had a surgical navigation invention, and you start asking the question, why? And you're doing surgery and navigation to make hospitals more efficient and to make the time being less. So why not add sort of to your surgical navigation system sort of the best path for time to get the operation done? Now it's being driven by an abstraction that the business is really looking to do. So you can apply this why to any invention and start to quickly see that you can raise the value of your invention disclosure. Another thing you can do in business is what I would call value type expansion. That is, you can try to find out whether your invention disclosure should be more valuable for sort of licensing or M&A or litigation or brand. So suppose you have a semiconductor chip and you're cooling that chip, and that's what your invention is. And then you kind of figure out that you could extract this thing to real-time power management. So you can use the real-time power manager to figure out how much cooling. And therefore, when you do that, that makes this patent or invention really useful for data centers. And it turns out the data centers are looking to license technology to help data centers. So this is a way that through the invention disclosure process, putting the business hat on, you've moved it from a cooling invention to one that's going to help with real-time power usage, where you know that there's going to be more valuable relationships for licensing. One of the strongest ways to do business grade, you kind of inventing disclosure improvements is connecting your invention to the customer. So think about this. Supposing you have an industrial pump sensor invention, and then you decide to say, when I'm selling this to my customers, what they really want is the pump to be efficient and have low maintenance. So what you do is you sort of recognize that they're using your pump, but they're adding all sorts of things to the pump so that they can come monitor. Well, what if you were to add to your industrial pump kind of a failure cost dashboard connection so the plant managers can actually see in dollars the downtime of the pump? So that's customer connecting, right? You're connecting your invention to what the customer wants. And by having a patent on that, the industrial pump with an industrial grade dashboard, for failure, projection and cost accounting, it becomes a much more valuable invention. Creates a lot more value for that invention. By the way, when I'm talking about these business grade upgrades, most of them are 2 or 3 paragraphs and one other figure to add to the invention. Why not do it? Another area is sort of value expansion. Here, what you can do is you could try to figure out with your invention, how to get, maybe the intellectual property type to change. Maybe you've got a method to do something, but maybe you can create a business model from it. So suppose you had a drug delivery device, and the invention was enhance what you can do with it. You can use it to actually, monitor the pressure of the drug delivery system to actually see if the drug delivery system with the use meter is being used, against a lot of back pressure or not. So you've got a drug delivery system that you're inventing, but you say from a value expansion, what I'm really trying to do is to try to look at the model. So what I want to output from the drug delivery system is other parameters like the pressure that I need in order to get the drug delivery over a period of time. So that tells me something that maybe medically I might be interested in. So you can have a value expansion of your drug delivery device, giving information to the doctor. So by value expansion, it's not just your customer. It could be a user. It could be somebody in that value chain. Another key thing to do for business grade inventing is sort of market value, like determining the value of something. We've talked about smart meters before. Let's do it again. Suppose you have a smart meter invention and you decide what you want to do is detect and prevent energy theft, because what happens is that have this kind of real-time system whereby you kind of the smart meter is measuring the power to your house, but in your neighborhood there are a lot of people that are playing games with stealing power from each other, and also there are times when power costs more during the day, and so you're trying to develop a system that's not just measuring it but adding some value add. So here what you have is some sort of first time system that understands that maybe the power is being used for something that it shouldn't. I had a client one time that was trying to figure out why his power bill was so high. And he found out that his kids, when he left in the lunchtime, were jumping in the hot tub and spending about an hour there a day. And he told them not to, but through his power, he saw that the power was being stolen really by his children. So having a smart meter that could produce reports on usages that are not normal, making it kind of ready, provides some value to the business. And now they can have a smart meter, they can sell it because they're the first to have sort of a stop power theft model. A couple other things. I think one of the big things about business is ROI triggers, return on investment. And you could have your invention expanded to do all sorts of things. Like supposing you have a warehouse robot and you want to enhance it in such a way to let the customer know how valuable it is. So supposing your robot gets trained to do pick and place of packages. Well, what would happen if you could sort of in the invention disclosure of your robot that's doing pick and place, that you could basically have a rate that compares how well the robot is picking and placing to the average person picking and placing. And what happens is the output is of the robot is not only doing the job, but it's continually telling the customer its savings. So now, because the robot's doing the job, so it could actually know at the robot level how much time it's saving. So now it could output that. So putting ROI, return on investment, into your invention. So you think about your invention, you're writing a disclosure, and you say, well, how can somebody get an ROI by doing this? And then you add the technology to have the output of the ROI. Now, finally, I'll give you one that sort of helps businesses a lot. It's called platform building. And here we find is that inventions can be enhanced if they can move their invention from where they're at to enhancing a platform. So suppose we'll go back to a smart thermostat again, and the invention is to add Wi-Fi connections. Imagine if you're adding a Wi-Fi connection and you're now connecting that Wi-Fi for your smart sensor to the cloud, and you have a user interface that helps you manage it. But now supposing that you can kind of think about it as a platform that you sort of ask the users where they live, and so you get geolocation data. And what happens is that data ends up in the company's cloud, along with the Wi-Fi connection data of the smart thermostat. So now what happens is the company now knows about geolocation and what's going on with temperature changes in houses. So that allows them to take that data and then forecast it, which then allows them to create optimization algorithms to load back to their smart meter, which then allows them to have this software as a service. And as I keep talking, I keep expanding this. But what I'm doing is I'm taking the invention of the inventor, which is a smart thermostat with Wi-Fi connection to the cloud, collecting geolocation data, to turning it into a whole new business by building a platform around it. So think about your invention in terms of how to expand it in a platform. So boy, there's a heck of a lot to do by either inventor-led or business grade on top of what the patent counsel's already done. And so the way I decided to portray this is give you specific thinking tools and give you specific examples of that, just so that you get the idea that there's a lot of opportunity here. Now let's go to topic number 6, the value of doing both of them, inventor-led and business grade. So first of all, on the record, inventor-led and business grade is not what patent counsels do. They create a value in and of itself. And by the way, if you have an inventor-led business grade invention and then you give them that document, they could do a lot more with it than just an invention disclosure you might have written without that thinking in it. First of all, one thing that's really important about the inventor-led side is the eyes and experience from an inventor's point of view. I mean, you're writing an invention disclosure, right? Suppose you're doing a tax document. Wouldn't you want a tax expert to help you with that tax document? So why on earth would you write an invention disclosure without having an inventor help you? It just sort of makes practical sense. Another thing is inventor-led adds all these enhancements for value along the thinking lines of how an inventor would do it. They'll take all sorts of things and allow you to get many more continuations from the same patent than you could before. So that means the success of issuance soars. It means you're going to get more patents out of the same disclosure. So why not do it for that reason? Another really valuable thing about inventor-led disclosures is it enhances the company's value. It leads to new products, new platforms, as I just mentioned, new technologies. Sort of the inventor creates an invention, and you know this is true. They walk away from writing the disclosure. They're not going to stop inventing, and they'll go off and maybe trip into one of these things down the road. Why not spend the time at the invention disclosure level to do the thinking about expanding it along the invention lines instead of let it happening randomly to you. Another thing is if you do this invention expansion technique on your inventions, you're building the inventive muscle. The most recent podcast we just had is on building the inventive muscle. Clearly, inventor-led inventing disclosures is a way of building your inventive muscle. If you end up doing this as an inventor, you'll become a much better inventor. As a matter of fact, if you do this as an inventor, you'll start inventing more. If you do this as an inventor, you'll have many more inventions. One disclosure now can be 10, 15 continuation patents versus maybe 2 or 3. If we switch over to the business grade thinking, of course, there's an ROI enhancement. The IP becomes a better material asset. It makes it more valuable. Generically, we talk about that, but there's a lot of specific ways it makes you more valuable. It's certainly the invention business grade is enhancing the savings because for the same write-up that you're going to pay for the patent counsel, the filing with the patent office, and the office actions, for that same cost, you have the ability of having so much more claimable subject matter in your specification. So it's a great savings. As a matter of fact, doing business grade inventing might actually, become your IP strategy. Another thing about business grade is it really enhances the asset. I mean, the difference between something that's business grade written and ones that isn't could be the difference between licensing for 500,000 or selling the patent for 4 or 5 million. So there's a real asset value difference here. Another thing about business grade is it enhances the future of the business, not just the ROI. Because if every invention that you file went through business grade thinking, you'd be building and compounding the direction of the value towards the business. And then finally, you do them together, inventor led and business grade. First, you do inventor led, then you do business grade. You may go back to inventor led, but wouldn't it be great to just have one facilitation process where you do them together? And that's what we would highly recommend and what we do. Inventor led, business grade, and then get patent counsel involved. It's kind of like those three, the inventor, the business guy, and the patent. They're kind of like the patent Avengers. I mean, you need strengths from the different Avengers for different reasons at different times. Some needs to fly, and some needs to stop, a bomb from, some needs to go invisible to be a spy. You need these kind of skills to be an Avenger. So why not have more skills around the invention disclosure Avengers here? So let's wrap up. Had a lot of fun talking about this, and we hope that this inventor-led business grade invention disclosure idea can be used in your organization. It doesn't cost that much in time to do it, but it certainly has a lot of value. In topic number one, as you recall, we talked about definition, process, type, etc. We talked about it was the first step of the patent process, from napkin to thesis. We talked about it's often skipped. We talked about point of view matters. For management, it's the first time it logs human capital. For the business, it has a docketing system. And if you do it right, you're minimizing billable hours for your patent counsel, etc. And it's there to ensure quality and enablement. There's a lot of structure to that invention disclosure, even though there's a lot of variation to how you do it and who does it and when. In topic number two, we talk about the invention disclosure to the provisional or patent and the problems we found. And there's a lot of problems. We talk about little understanding of claims or enablement. Nobody really understands prior art. They all get confused with obviousness. They don't really know what IP types. Is it a method? Is it a composition of matter? And you sort of think about this, and it too often misses even some of the simple inventor kind of inputs of inventing around, value chain invention, etc. So there's just so many sort of inventor flaws. And then we found problems associated with the business, like writing the invention that's not going to help the company against its competitors, help the brand, help the investors, improve the valuation. I talked to a guy 2 days ago that basically said his company, they raised a bunch of money and he was in charge of the portfolio and they got hundreds of patents. And he said, I'm sorry to say that for some reason, and partly my fault, we ended up filing so many patents that we didn't recognize how much they were going to cost as they went through the process. And over the first 2 years, it was so expensive. We had to take all those patents and reduce them down to just a handful. And by then, we'd run through so much money that it became the major reason why the company was disinvested from. So the very nature of trying to build an asset was done totally wrong. Boy, if they could have done inventor-led and business grade, they would have had 1/5 the patents, but each one of them would have been so much more valuable when they needed them. In topic number three, we talked about what the patent counsel does, certainly value add. They're the ones that sort of lead the legal requirements, manage the dates, manage the fees, make sure it's compliant with the MPEP. They're the ones that help determine enablement, file continuations. They're writing claims. They determine inventorship. They help with the office actions. They'll then move it into evidence of use of freedom to operate. Clearly, a skill absolutely needed. But then we said, given that skill, let's talk about the inventor. We talked about inventor-led invention disclosures by adding inventor thinking, like, not patent counsel point of view, but the tools of inventing around, inventing on top of, figure abstraction, enablement thinking, species, genus, trade secret, master disclosure thinking, and possible problem expansion. We gave a whole bunch of examples for that. Boy, is it fun to do it, but boy, with that level of thinking, can you expand that one invention disclosure? Then we went in to talk about the business grade invention and how basically it moves into business thinking. Not a lot of books written on this. I'm sure you could take any book written on how to make a better business and apply it to the invention disclosure. But it does things like improves the company's strategy if you can relate your invention disclosure to the company's business strategy. Value chain expansion, the how, why ladder we talked about. We talked about connecting it to customers or connecting it to ROI triggers or even making a platform out of your invention disclosure. There's all sorts of ways to improve the business value. And then finally, the last topic, which we just ended up, is what happens when you combine these two things together. You get the invention led, and business grade together. It goes up because it's adding more value from the invention standpoint, which then makes it goes up because of the business grade. Because of the business grade goes up, it might influence more invention, and so that goes up. So it allows for things like higher issuance, stronger product platforms, stronger outputs of technology, much stronger patents. It basically allows you to flex the inventive muscle while business grade thinking. And by the way, these patents at the end of the day become a material asset. So doing business thinking and invention thinking in the disclosure process is a great savings because you're doing that sort of on the document versus in practice in reality. There's such a lot of good benefits of having an inventor-led business grade invention disclosure. Well, look, if you like what you heard, please subscribe. Join us in our blog, Invent Anything. And this is John Cronin saying thanks for listening from Invent Anything.